If you file a motion for disqualification either to the original judge or to the successor judge, perhaps, and it's denied, what are your options? How can you seek review of that order? And the answer, something called a petition for writ of prohibition that would be directed to the appellate court. A writ of prohibition is simply an action in the appellate court to challenge that a public official, in this case, that would be the trial judge, to challenge the jurisdiction of that public official to act in a case. And that fits perfectly with the disqualification because the entire point of the motion is that the judge shouldn't be acting on the case because of their bias. So prohibition, there is no actual specific time limit to file a writ of prohibition, although the case law indicates that the writ should be filed within a reasonable time. And failure to file the writ within a reasonable time, probably within 30 days, but it could even be sooner, perhaps based on the circumstances, is grounds for the appellate court to deny that writ of prohibition. It's also important, corresponding to the different standards applied to a motion to disqualify the initial judge and a motion to disqualify the successor judge, the standard of review on appeal or on the writ of prohibition is different for those two rulings. For the initial motion, the appellate standard of review is de novo, which means it's simply a question of law, and the appellate court doesn't give any deference to the decision of the trial judge in ruling on the legal sufficiency or timeliness of the motion. Where you have a motion for disqualification directed to a successor judge, however, a writ of prohibition, the standard of review by the appellate court is abuse of discretion. And that makes sense because the successor judge is actually going to look at the evidence and decide whether, as a matter of fact, that he or she is biased and cannot provide a fair trial to the party. So that motion would be reviewed by abuse of discretion.